We've got major developments in the legal fight against the ATF's pistol brace rule. You already know that the Trump DOJ agreed to drop their Fifth Circuit Court of Appeals case in the mock lawsuit. And recently, the ATF moved to settle several other pistol brace challenges as well. But here's what matters. One of these cases is pushing forward to permanently block the ATF from implementing any pistol brace restrictions in the future. This is absolutely critical to protect these items if a new administration takes office down the road. So let's break down what's happening in this important case. Real quick before we get into this, if you want to support the channel, one of the best ways to do that is simply to subscribe. That helps the channel grow and reach more people. All right, so we've got some significant news in the battle against the ATF and their restrictions treating braced pistols as short-barreled rifles. The Trump DOJ recently told the Fifth Circuit that they've agreed with the plaintiffs in the mock lawsuit to drop the active appeal on the pistol brace case, and they conceded that the prior nationwide vacatur issued by Judge O'Connor can go into effect. Recently, other pistol brace lawsuits were also dropped and deemed moot because of what happened in the mock lawsuit. But now, in a third case filed by Gun Owners of America and the state of Texas, they're asking the court not to dismiss their challenge. Instead, they're pointing to the ATF's continued enforcement of pistol brace restrictions. In this case, they're asking the court to issue a permanent injunction that would block the ATF's enforcement of any pistol brace restrictions going forward. This matters because if granted, it would prevent any future administration or any future ATF from going after these braced pistols. Now, you may remember that the ATF recently suffered multiple losses in various pistol brace cases. Not only did they have multiple preliminary injunctions issued against them, but Judge O'Connor also issued a final merits decision striking down the pistol brace rule nationwide with a nationwide vacatur of that rule. In response, the Biden ATF at the time decided to appeal to the Fifth Circuit. There was a temporary stay in that case while the Trump DOJ was taking control and figuring out how they wanted to handle this issue. Eventually, the Trump DOJ decided to pull the appeal at the Fifth Circuit level and concede the mock case in favor of the plaintiffs. So in the mock challenge, the ATF agreed that Judge O'Connor's prior nationwide vacatur of the rule would now go into full effect, and the ATF would recognize and concede that decision. That was the first domino to fall regarding pistol braces, but there were other lawsuits still pending. You had other lawsuits in the Fifth Circuit, like the Gun Owners of America and Second Amendment Foundation cases. And then you also had the Brito lawsuit in a different circuit court. Recently, we saw the ATF and the Second Amendment Foundation send a notice to the court that in light of the mock dismissal, they were also actively moving to resolve their case. The same thing recently happened in the Brito lawsuit, and they also moved to dismiss the case based on the mock challenge and what happened in the Fifth Circuit settlement. Now, one thing I've been pointing out in these videos is that there are some long-term implications to these decisions to drop these challenges. By agreeing with the Trump DOJ to drop the cases, you get an immediate win, and you end the pistol brace enforcement under the rule right here and now. But you also lose the opportunity to get a larger, more impactful final merits win in a court of appeals. Remember that the mock case was only ruled on by a district court judge and was only based on the Administrative Procedure Act and some administrative procedure issues regarding how the rule was put together and how it was implemented. If another anti-gun administration comes into office and they decide to take another shot at the pistol brace rule, the only precedent you really have is in a district court in that mock case, and all you really have is an APA procedural violation. So they can modify the rule or try once again to get a new rule on the books. It also doesn't prevent the current or future ATF from saying that they can still regulate braced pistols based on the statutory language itself. And now all of this is being brought up by Gun Owners of America and Texas in their challenge against the ATF in their pistol brace case. Recently, Gun Owners of America and Texas filed a status report in their case on this whole pistol brace issue, and they're arguing that their case should not be moot. It should not be dismissed. Instead, the district court here should issue a permanent injunction against the ATF's current and future enforcement of any pistol brace restrictions. Now, in this report, Gun Owners of America and Texas state that the court ordered a status report on October 24, 2025, and that if any party believes this case should not be dismissed because defendants appear to believe that they are free to continue to enforce the statutory interpretation underlying the final rule, even though the rule has been vacated, plaintiffs' claims are not moot, and this case should not be dismissed. Rather, the court should enter an injunction permanently preventing defendants from ever enforcing their flawed legal theories against the plaintiffs. They state that in this case, subsequent activities by the defense have raised serious doubts about their willingness to comply with this or any other court's ruling. For starters, the rule was vacated on procedural grounds, not a rejection of defendants' underlying statutory interpretation. And without injunctive relief, defendants are in a position to simulate enforcement of the rule merely by referencing the underlying statutory scheme defining the NFA's registered firearms, which they're talking about short-barreled rifles. Thus, without a permanent injunction, the risk to plaintiffs caused by defendants' flawed legal theories actually remains. They then point out that there have been multiple situations recently where the ATF has tried to enforce the pistol brace restrictions under the underlying statutory language. So instead of pointing to the rule, they say, well, we can do this under the statutory language of the NFA. They state that, for example, in United States v. Tirado, the individual was charged with having an unregistered short-barreled rifle because he had a braced pistol, a CZ Scorpion. And they also point out how Gun Owners of America got some emails from some of their members where the ATF claimed that the federal statutory law still requires that braced pistols be registered with them as short-barreled rifles. They point out that as defendants candidly acknowledge, ATF's enforcement of the statute will necessarily incorporate factors like those discussed in the rule. Again, the rule has been enjoined, stayed, and even vacated by numerous courts. But defendants believe that since the rule was vacated on procedural grounds, and no court has held that the rule is on incorrect interpretation of the statute, any vacatur has no real effect. Rather, defendants' interpretation of the statute can move forward unimpeded as if the rule was still in effect. So, even though the rule has been vacated, they state that the plaintiffs have not received all the relief they sought, and certainly not all of the relief they need to be protected against the defendants, the ATF, and their flawed reading of the statute. So until the defendants wash their hands of the statutory interpretation underlying the rule, and until they are enjoined from enforcing their flawed interpretation of the statute against the plaintiffs, the fight must go on. To that end, they state plaintiffs intend to seek leave of court to conduct limited discovery on defendants' continued enforcement of their underlying legal theories, and therefore file a renewed request for a permanent injunction for relief. So this is good news for the future protection of braced pistols. Gun Owners of America and the state of Texas are moving to get a permanent injunction against the statutory interpretation of the NFA trying to treat braced pistols as short-barreled rifles. This would protect people currently if the ATF tries to go after you under the statutory interpretation, but also potentially protect people going forward. That way, maybe a new rule cannot be put in place, but also so that maybe a future administration cannot simply try to go after braced pistols based on saying, well, the NFA statutory text alone allows us to go after braced pistols as SBRs. So this is good news. And I'm glad to see that Gun Owners of America and the state of Texas are still trying to move this forward to get a more solid resolution and block any future implementation of the statutory language against braced pistols. So that's what's currently going on right now in this critical pistol brace challenge. Now we'll wait to see how the Trump ATF responds to this request and this new notice to the court, and ultimately, how the court responds to this request as well. As we get more information as it develops, I'll let you guys know. If you liked this video and you want to support the channel, one of the best ways to do that is to like, comment, and subscribe. But as always, thank you guys so much for all of your support.